apologise again for being rather late. You're no doubt thinking we could have had another 5 minutes over our lunch, but that's life.
It is indeed.
Right. I imagine Mr. Blundell spent his lunch looking at Section 2 of the Jamaica Constitution Act. But
well, Sir James played a part of the lunch. I've been in discussions with Ms. Brown about that, and we think we know the answer, but there's one point we want to check if that's...
no problem at all. You can come in an email afterwards. Yeah,
very grateful.
Yes, Mr. Afghan.
So before I move on to deal with the criticisms of Sir James of the judgment on the assumption that the judge is right, that the statute is capable of allowing a policy, I just want to persevere a little bit, not for long, in relation to what is, it's turned out to be the critical point in this appeal, or one of the critical points in this appeal, which is whether or not, on Padfield grounds, any such policy or alteration to the policy would be ultra vires.
Yeah.
And I did mention before lunchtime that this is not a point that the defendant, the appellant has taken till now, and I've gone back to their skeleton, and indeed it isn't. And I do just want to look at how they put it, because in our submission it actually is of assistance to the interpretation of the provisions. So if you can turn to their skeleton argument in the core bundle at paragraph 25, page 21, page 20, I'm sorry, I've got the electronic bundle, I keep looking at the wrong page.
Fine.
So page 20. And this is the part of the skeleton addressing why the court should back off, as it were, and why Mr. Justice Swift was wrong to get us stuck into the policy as he did. And at paragraph 25, it is argued there are compelling reasons for the public law outer perimeter to be set broadly. First, the policy approach to the statutory requirement of good character relates to social policy. That social policy concerns access to citizenship rights and thus the basis upon which individuals may claim the protection associated with citizenship and the rights which flow from such allegiance. And then goes on to point out that once citizenship has been granted, one of the tools in the state's machinery to respond to criminality goes, and that's the deportation point. Mm-hmm. So we know that before somebody is granted citizenship, ordinarily, if they commit criminal offences, they can be deported. However, of course, that's not the case once citizenship is granted, and the only way then to respond is to deprive them of their citizenship, which requires far, far more stringent grounds to do so. But we also know, just in parenthesis, that in relation to this particular group, as Sir James has readily accepted, in fact, they cannot be deported even if they're not granted citizenship. So that particular tool goes out the window in relation to this group. But that's not relevant to statutory construction. It's just a consideration as to how, if the statute permits it, you might want to revisit the character requirement for this group. But he goes on then, or the skeleton then goes on to say, the application of a good character requirement, this is at the bottom of the paragraph, 4 lines from the bottom, is therefore essential, ensuring that British citizenship and all that comes with it is only granted in appropriate cases. So the breadth of that discretion is there to allow the Secretary of State to make sure you only grant in appropriate cases. And we go on to the next paragraph. It is a crucial element of control available to the Secretary of State, not only to ensure the grant of citizenship is made only in appropriate cases, but also to ensure public confidence in the integrity of the naturalisation process. So citizenship should only be granted in appropriate cases, and the integrity of the naturalisation process should
fair enough. I see why you, but I do think you need to read the second sentence as well, which suggests that Sir James and Mr. Blundell were considering appropriateness in the context of criminality or good conduct, not more generally.
Well, absolutely in the context of criminality and good conduct, but what constitutes acceptable criminality or good conduct and makes citizenship appropriate varies according to extraneous circumstances. So we have, from the Secretary of State's own mouth, an acceptance, and it's there in the wording of Schedule 1, of an extremely broad discretion.
But that's not
leaving it to the Secretary of State to define what constitutes good character. Now, in my submission, there is nothing in terms of the purpose that broad discretion must serve, as identified there, which prevents a decision maker from deciding that the definition of good character, and therefore what constitutes bad character, as it were, is one that is variable or will apply differentially according to different characteristics of different groups. So, for example, if we come back to the social policy concerns access to citizenship rights, and thus the basis upon which individuals may claim the protection associated with citizenship and the rights and obligations that flow from such allegiance. If one looks at that and one steps back and says, given those important considerations, the fact that somebody has been here since their birth and is considered by the state and by everybody to be British in all but legal status is something which can have a bearing properly on whether it is considered appropriate for them to acquire citizenship despite or in the face of whatever conduct they have been engaged in their life. And the appropriateness, the acceptability of their acquisition of citizenship in the face of their conduct will be judged differently and can be judged differently because of those features that characterise them as a group. And there is nothing wrong with that, and there is no reason why the Secretary of State cannot, within the breadth of that very, very broad discretion, say, yes, this is a requirement that cannot be waived, it is set down in statute, but I define what constitutes good conduct, and that can vary according to the circumstances of and attributes of particular groups. At all times, the question being, is it appropriate, despite their conduct, for them to acquire citizenship? Is it something that is going to command public confidence? And is it something that will ensure that I have the necessary control that I want? At the moment, it's just a question of gateway. Does the statute prohibit this? And in my submission, the statute does not prohibit it. That is an altogether inappropriate constraint on the breadth of the statutory language and the power and broad discretion it confers on the Secretary of State as to how he defines good conduct or good character. So those are my submissions on that. Can I then move on the assumption I'm right on that? And as the Secretary of State until this morning has always accepted, it's not that this is impossible or ultra vires, it's more that it was an impermissible step for the court to take. On the assumption I'm right about that and that Mr. Justice Swift was right, can I then move on to the criticisms that are made of the approach taken by Mr. Justice Swift, by Sir James? So firstly, the argument that the broadest discretion must be conferred on the Secretary of State, and these arguments that I've just rehearsed. And the answer to that comes back to the answer that I rehearsed this morning. If I'm right, or if the judge was right, that logic, rationality and consistency required an application of the principles across the span, so that's the second point I have to make good, but if we're right about that, and the statute enables that, and a rational decision in the face of the statement of Amber Rudd required that, then the fact that the broadest discretion has been conferred on the Secretary of State is neither here nor there. What the judgment of Mr. Justice Swift it amounts to is simply saying, well, in the exercise of the broadest discretion that you have, you have yourself identified the consideration and the factors that are going to drive your approach. And in light of that, you are compelled to take some action in relation to the good character requirement. And that answers also the second criticism of Sir James in relation to the judgment, which is that the judge completely ignored all the other measures that are taken. If the judge was right, then those other measures simply exemplify the irrationality and the illogicality and the inconsistency of his failure to make any amendments in relation to the good character requirement. Now, I must make clear, because there seems to have been some sort of criticism from Sir James that the judge then stood back, as was, in my submission, entirely appropriate given his constitutional function and that of the Secretary of State, and said it's not for me to decide how you go about giving effect to these principles. That's entirely a matter for you, because you, of course, have to weigh up all sorts of other things, and how you weigh them up is down to you. My criticism of you is that you have given no effect at all. So, for example, we have Amber Rudd, and we know what she intended to do. What she intended to do, we can see from Philippa Rouse's statement, was to say, I'm going to give effect to this principle by making sure that where we're dealing with minor offending, there will be no contravention of the good character requirement by reason of such minor offending.
You're reading a lot into the statement. She doesn't say that expressly anywhere.
No. She said it in Philippa Rouse's statement. We can see that that was the consequential. I can take the court to that. She didn't say it at all in the Windrush statement.
No, I thought the basis of your case was what she said in the Windrush statement and what you describe as principles in that statement.
I'm sorry, I'm not making the point here that
You haven't got to that point yet. You're making a different point.
I'm making a different point.
Right, okay.
The point I'm making here is that Mr. Justice Swift did not seek to prescribe how the Secretary of State went about exercising his very broad discretion. The limit of his criticism was that this was a factor to which you, given your statement, or given the Secretary of State Amber Rudd's statement, were required to give some effect. How you didn't do that. How you go about that is a matter for you. So the point I was trying to make...
I've got that point.
But that sounds good, but I'm uneasy about it. Suppose he or she, whichever it happened to be in the end, had said, yes, I see the logic of what I've said in the Windrush statement requires me to do something. And what I will do is I will say that the category for least serious offences will be spent after 1 year rather than 3. Could you have challenged that?
No, in those circumstances, a challenge would be extremely difficult because he then does have an extremely broad discretion as to how he's going to weigh all...
You're saying as long as he does something, as long as it's not de minimis, I can't object. Well, it doesn't seem very principled. The principled position, I'll put it, what I've always understood to be a principled position, and ignore the question whether it would require primary legislation, would be the principle here is to put you in the same position as you would have been in if you had been effectively before 1st January 1988, in which case you wouldn't have been subject to a good character requirement, and therefore I need to abolish the good character requirement, and I'll promote a bill that has that effect. That has a logic to it. And again, if the principle is everybody in the Windrush may be naturalised, which is what she does say at one point, that's how you would have to do it. But that's not actually your case. Your case is, no, you've got to do something, but it doesn't have to be as much as that. So
on the basis that what is then done, so you, on the basis of your own principled statement, have said, my decision-making about this particular cohort is going to be driven by a need to reflect in their application for citizenship and the criteria they have to meet the fact that they are their long residence, their close ties, the nature of the Windrush scandal. That is something that is going to be reflected. How
But you
it
do
is
that
then
by saying no fee and taking out the requirements of English language and knowledge of life in the UK.
That comes back to the prior point, which is if you express that set of principles as animating your approach, are you required to do it across the board? And you have my submissions on that. And my submission is yes, you're required to. How you then do so as a matter of, because this is a strict public law challenge, it is on the basis that you, the Secretary of State, have set out your stall, as it were. You have made clear the considerations that are going to drive your behaviour. Now, once you have done that, you have to act rationally in accordance with that stated basis upon which you're going to act. So, again, for the court, that is the limit of what it can do by way of supervisory jurisdiction. It is then for the Secretary of State to go about and exercise his discretionary power. I can't say whether or not, standing here, absent his having undergone the exercise, or her having undergone the exercise, whether or not there would be a challenge. It would depend. But it would be, because it would be a conventional challenge, very difficult of its nature, given the broad discretion and so forth that the Secretary of State enjoys. I have to recognise that. There's a very narrow basis upon which this decision has been reached. But the point I'm making is that the fact that the Secretary of State has so many different matters to take into account does not demonstrate that there is an error in Mr. Justice Swift's approach in not having set out what it is the Secretary of State should do. That is entirely proper because it is a matter for the Secretary of State.
That's very helpful. I see exactly how you put it. Thank you. But that was all you were, in a sense, clearing the ground from some secondary points. You hadn't yet come to the primary point you've got to establish, which is that this is what the declared principles were.
So I thought I had established what the declared principles were, which are, if one takes from paragraph 34 of the judgment and paragraph 35, the declared principles are, as I articulated.
But don't we need to look at the Windrush statement and see whether she did
Yes.
declare those statements?
Yeah.
As principles?
Oh yeah, yeah, absolutely. Let's go on to the statement.
Page 124 of supplementary under 1. I put a question about the structure of the statement, which I'd like to ask you at some point, when it's convenient to you, please, Ms. Calvin.
Yes. So, page 121.
Sorry, 124, I think.
124.
That's
yes.
the page I've got.
So the first relevant articulation of principle is all members will have seen the recent heartbreaking stories of individuals who have been in the country for decades struggling to navigate an immigration system in a way that they should never ever have had to. And she then goes on to explain.
That's not a principle, that's just a description of the situation in which they were.
Yes, but if we're going to have to read the whole thing in context to see
Yes.
what then animates the changes that she then announces. So, she identifies the critical features about these individuals. They are British, and we get that 3 lines down after she's talked about their deep, deep integration into United Kingdom life and culture. They are British in all but legal status, and this should never have been allowed to happen.
So what's the this that she's referring to?
That they were caught up in the
Struggling
hostile
to
environment.
Yes, okay, that's the this.
That's the this.
Yeah.
So she then goes on to say, I am personally committed to resolving this situation with urgency and purpose. So she's identified the scandal they were caught up in,
Yeah.
This happened to people who are British in all but legal status.
Yeah.
And then she goes on to say,
I'm sorry, where are you
I'm
precisely?
so sorry, we are on the second paragraph
Of 124.
of 124. And she then explains,
how the situation has arisen. Now, can I just ask my question about the structure while it's still in my head, please? So that sentence says, but before I go on to the steps we will be taking, I want to explain. So she then sets out the background. And she tells us about what's gone wrong and why it's all bad. If you then go over to page 125, the second full paragraph, want to know the Windrush generation quickly at no cost and with proactive assistance. First, I will waive the citizenship fee. Secondly, I will waive the requirement. Thirdly, children. Fourthly, people who've retired and gone back. She then talks about what the task force has done so far. And she...
Yes, I imagine Ms. Kaufman would want to draw attention to the final sentence before we get on to where my lady was taking you. In effect, that means that anyone from the Windrush generation who now wants to become a British citizen will be able to do so. I mean, maybe you don't attach importance to that. I think there are some problems about your doing so, but the judge did.
Yes, there are other parts that I'd like to draw attention to.
Yes.
But just to go back to the point I'm making, the point I'm going to put to you is that the structure of this is that Ambrod explains what's been terrible about the situation, and she then says what steps she'll be taking to put it right. So she says, on page 125, I want to enable them to acquire the status. First, I will waive the citizenship fee. Secondly, I will waive the requirement. I shall waive the fee, that's third. Fourthly, I will insure. So, again, I will waive. So she's setting out the steps that she as Secretary of State will be taking to put the situation right. So my point is that's the structure of the statement. I just want to give you an opportunity to comment on that.
I don't know whether there are two aspects to the point you're making. One that is, it is Amber Rudd stating this, not Sajid Javid, or whether it is that she set out the steps there, and that therefore constitutes the totality of what it is said is informing her approach.
She's set out the background, and then she says, before I get onto the steps we'll be taking, I want to explain how this situation has arisen, and then she describes the various steps which she has taken, which she will take, and she goes on to compensation over the page and so on.
So two points in answer to that.
Yeah.
So in a moment I'm going to try and come back to extracting the principles, because I think there are other parts of this statement that we should look at.
Yeah.
Secondly, insofar as I can extract principles from this statement, while it is Amber Rudd that is expressing them, there was at no stage any distancing on the part of Sajid Javid from the principles expressed here. Third point is that, for reasons I'm going to show if we go back to Philippa Rouse's statement briefly, she was in no sense intending to be exhaustive here, and this was in no sense showing a decision as to the limits of how the underlying principles were to inform decision making, and that Mr. Justice Swift was entirely right to say it was a consequence of timing that no mention was made about the good character requirement.
Surely, if this is about, if the basis of the legal challenge is that when you have stated principles, you must follow them, we have got to look at the statement of the principles, and that's the public statement, not what Philippa Rouse says about the internal thinking.
No, I'm not making the point that there is internal thinking that that reveals anything about the stated principles. Rather, the internal thinking shows that those stated principles were ones that extended beyond what was identified here as the steps that were to be taken.
But surely that we've got to identify that either from what the statement says itself or not at all.
No, in my submission, no, that's not the case, because we're not dealing here with legitimate expectation resting upon what was promised.
Well, I know you've made that very clear, but even so, doesn't your legal basis, what I wrote down is, if you articulate a set of principles that will drive your approach to a particular class of decisions, then it's unlawful not to apply those principles consistently across all the criteria required to be satisfied. But surely we should only look for the articulation of the principles in their formal statement.
And that's all that we are asking the court to do, and that's all that Mr. Justice Swift did. So he looked at the principles, he did not look at the steps that were proposed to be taken. And for the very good reason that those steps were not the final steps, and this is not a legitimate expectation argument. It's not that she failed later, or Mr. Javid failed later to deliver on those steps that were identified there. It is that there was a failure to deliver on matters that were not identified. And the significance of Philippa Rouse's statement is that she shows that Amber Rudd at no stage when she articulated those principles was seeking to confine herself to those measures, because she was already looking at...
But we can't construe a public statement by reference to what was subjectively in the mind of the person who made the statement. We've got to construe it by reference to its words, surely.
Yes, and the public statement, by reference to its words, sets out the principles that are driving the behaviour, the decision-making. The scheme hasn't yet been set up. She's identified some of the steps that are going to be taken in respect of that scheme.
You've said that you wanted to take us to other parts. We should let you take us to those, and then we'll resume our questions if we have any.
So she, if we could go back to the bottom of page 124, so she sets out the legislative history, and then she makes the point: the public expect us to enforce the immigration rules approved by Parliament as a matter of fairness to those who abide by the rules, and I am personally committed to tackling illegal migration because I have seen in this job the terrible impact it has on some of the most vulnerable in our society. But steps intended to combat illegal migration have had an unintended and sometimes devastating impact on people from the Windrush generation who are here legally but who have struggled to get the documentation. This is a failure of successive governments to ensure these individuals have the documentation. So again, another appeal to the scandal. This is why we must urgently put it right, because it is abundantly clear that everybody considers people who came in the Windrush generation to be British, but under the current rules, this is not the case. Some people will still have indefinite leave to remain, which means they cannot leave the UK for more than 2 years, not eligible for a British passport. This is the main reason we have seen distressing stories. I want to enable the Windrush generation to acquire the status they deserve, British citizenship, quickly at no cost and with proactive assistance through the process. And she then sets out what she wants to do. So this,
well, the key sentence is the sentence you've just read, isn't it? That's the key sentence. I want to enable the Windrush generation to acquire the status they deserve quickly, at no cost, and with proactive assistance through the process.
yes.
If it's right to describe that as a principle, that is what, I don't know whether it is, that is what she is aiming to do.
Yes, and she's aiming to reflect the fact that they have been taken through this scandal and had to live through this scandal and have their lives devastated, and that they are British in all but legal status because they are people who have grown up here, lived their lives here, and are...
It's not a question of all people, obviously, within this cohort being granted citizenship as of right. It's enabling them to acquire it and to remove the impediments to them doing so.
Yes, in order, and so to reflect the characteristics of this group in the conditions and the criteria that apply to the acquisition of citizenship.
You accept that the maintenance of a good character requirement was appropriate?
It's necessary, it's required by law.
Yes.
I absolutely accept that. The question then becomes one of how you reflect what animates the action that is to be taken for this group, how you reflect it in making amendments to that requirement. So those are the principles that I, in my submission, have been correctly extracted and identified. It's a combination of the injustice meted out to a group of people who everybody thinks of as British because of their long residence and close ties to this country, and measures are going to be taken that will assist them in securing the citizenship that they deserve.
Yeah, but deserves an important word, isn't it?
Well, it is an important word, but deserve is one that takes account of their Britishness in all but legal status. So it takes account of the fact that they are individuals who've been here for the entirety of their lives and are wholly integrated into British society. And that is
British citizens are British citizens, whether or not they're a good character.
Yes, absolutely.
So why does the good character requirement
Apply to them.
logically it must follow that should be waived as well?
Well, it can only be waived if you amend the statute.
Yeah, but she could have
As
committed
long as you've
herself
got
to
the
do that.
statute,
She didn't.
as long as you've got the statute, you and there's no way in which one can compel the amendment of a statute, but you can.
Oh, but sorry to interrupt you, but it's quite important. She could have said, and we will introduce a bill to remove the good character requirement, because if you're British, you're British whatever your character. She could have said that.
She could have said that, but equally, she could have said, okay, I've got to reflect this, which is what she wanted to do, but I also think that there are cases where the nature of the criminal conduct is such that the good character requirement should stay. It's an important mechanism of control, and in my discretion as a minister, I don't choose and think it's appropriate to go that far.
Well, Milady may be
that
right.
is-
That may all be wrapped up in the concept of what they deserve.
Well, exactly. So that's a movable feast, and that's why it's for the Secretary of State to decide exactly how the good character requirement falls to be revisited and amended in light of these critical characteristics of this generation. So one Home Secretary may take a much more generous approach to the Windrush generation, and another might take a less generous approach. But the point is, some sort of modification is required to give effect to the principles.
Okay.
So,
Well, why couldn't it be done within the context of the as drafted, with normally exceptional circumstances and generally the words that we've been looking at earlier?
can I come on to that later?
Of course.
Can I come on to that? Because I do want to look at the decision making, I want to look at the policy. I've just got a couple more points and then I will come on to the policy and as to why in our submission it just doesn't work where you have that generalised language, and that you need something that actually identifies this particular cohort and says in relation to them.
So you say the good character guidance should have been amended expressly to deal with the situation of this group of people.
Yes, and then how that is done is a matter for the discretion.
No,
of
I
the
understand.
I know it is, but are you going to suggest how it could have been done? Or are you just going to say it should have been done up to the Secretary of State?
It's absolutely up to the Secretary of State.
Yeah.
And I don't see that it's my position.
For my part, I'd like you
one example was the proposal of Amber Rudd, which is that for minor offending, you simply don't have a requirement. Another proposal could be, for example, minor offending, no period period required to be. You don't need to have passed 3 years or any time post conviction, but for more serious offending, it would have been open to reduce the period of time after which, or before which, the good character requirement is again satisfied. That would be another way. I mean, there are multiple ways to do it. For certain offending, very serious offending, don't treat them any differently. There are many, many options, and that will depend upon the sorts of factors that the Secretary of State chooses to put into the balance and how they are then balanced. But there are multiple ways in which it could be done. That's certainly not for the court. So, dealing with then another criticism, which was a criticism that the judge had, as it were, wrongly criticised Mr. Javid's decision on the basis it differed from Ms. Rudd's decision, Amber Rudd's decision. And in our submission, that isn't an error he made. He recognised ordinarily two different decision makers can come to totally different views. His decision wasn't based upon an inconsistency, simply, or rather a change of mind, being impermissible. It was on the basis that the principled approach had been identified by Ms. Rudd, and there had been no change to that principled approach on the part of Sajid Javid. It was just a wholly inconsistent approach to the articulated principles. Then there is the criticism that the judge failed to recognise that the good character requirement had always been treated as raising different concerns than the other elements or criteria in the immigration and nationality scheme. And again, in my submission, the judge did in no sense fail to recognise that by standing back and saying, it's not for me to decide how you balance all these factors and considerations. He was properly respecting the fact that there are all sorts of considerations that fall to be taken into account in this decision. He was simply saying
but what he says at the foot of page 73, paragraph 35, nothing in the 1981 Act compelled the decision taken in early May. Hasn't he applied the wrong test there?
No, I think that's the point, isn't it? That it wasn't the case that for Padfield reasons he was prevented from taking any other course.
I see.
And another point then made in the skeleton, I'm not sure whether Sir James made it today, was that yes, that it was reflecting the different considerations that arise in relation to the general, the good character requirement that explains why the Windrush statement made no reference to it. It only made reference to those other changes that we've just looked at. But the judge in our submission was entirely right to say that was actually an accident of timing, because we know, or not an accident, a consequence of timing, because we know, in fact, that Amber Rudd was looking at the good character requirement and was proposing that amendments were made to that. So it is not, certainly not, a reflection of those different considerations that resulted in that being left out of account. Then there is the point that there was a concern which was dismissed by Mr. Justice Swift, raised in the statement of Ms. Rouse, which we touched on this morning, about complaints by others being treated inconsistently. So those who fall outside the Windrush generation being treated inconsistently.
This is the point at page 64. Is it in Ms. Rouse's document? 64, supplemental 1.
Yes, vulnerable to legal challenges, good character should be an objective standard. So that point there.
I think that's quoted in the judgment, isn't it?
Yes, and Mr. Justice Swift dismissed that point. And firstly, it isn't a reason we've seen anywhere for the decision to make no alteration to the policy. Secondly, in our submission, and this is a legal question, it is not an obstacle to making changes specific to this particular cohort if, in fact, the court accepts primary submission that there is nothing wrong with applying a different definition of good character to different cohorts in respect of different characteristics that they have, which make it appropriate for them to acquire citizenship, then that complaint falls away because you are identifying.
As I understand it, the point being made here is that if the factors which justify a more flexible approach to good character are long residence and integration, then those qualities are not confined to this cohort.
Indeed, they're not, but it's not just long residence and integration, it's also long residence, integration, and the whole scandal. So that's another distinguishing feature.
So it would be a ground for differentiating between
exactly.
Windrush generation and others who'd been here for 40 years and were integrated, that they hadn't been subjected to the indignities and all that they had to go through.
Sorry, there's maybe a point I made before and didn't understand your answer. Not all the Windrush generation, in the sense of people who came here before 1173, were subjected to those indignities, because some of them obtained British passports. May also be that some, for peculiar reasons themselves, never had any problems by not having their ILR status recognised, documented. So the whole Windrush cohort isn't the subject of the Windrush scandal. Some are, some aren't.
So it would be down, again, given the broad ambit of discretion, it would be down to the Secretary of State to look at different cohorts and to make decisions, looking at those different factors and deciding whether or not they fall within a category where the good character requirement should be elevated in their case or not, according to where they fit in the entire process.
That does sound like opening the floodgates to litigation in every case.
So what you're saying, there could be different...
It doesn't open the floodgates if it's done on a rational basis.
So you're saying there could be different adjustments to the good character requirement for different people within the cohort?
Yes, just as there are different adjustments within the scheme for different people that are caught by the scheme. So the people within the scheme have different characteristics, as we saw from Mr. Justice Fordham's judgment. There are some who met both those components, and that's true of Mr. Howard. There are others who didn't, for example, that they left the United Kingdom and couldn't satisfy the 5-year residence requirement and so forth. So there are all sorts of different characteristics that individuals had, and in relation to them, different choices were made about how the scheme would operate.
But within the whole Windrush generation, there will be, as my lord has said, there are a cohort who have suffered the scandal and those who haven't. So there's a different of treatment will be justified there. Equally, there will be those who don't fall within the Windrush generation at all, but who have been here for a long time and have integrated, who may be deserving of a more flexible approach.
Precisely. And so, for example, the compensation scheme. The compensation scheme doesn't apply to somebody who wasn't affected by the scandal. That is to compensate people who have suffered because of the scandal. So it is a scheme that already...
It's a very different kind of policy then, isn't it? I mean, I'm not saying it's an impossible policy, but it requires judgment in every case, because just rather like the compensation scheme, you could have people who had some difficulties because they didn't have papers, but they overcame them. They never actually lost their jobs. They just spent hours of worry, months of worry and concern, trying to get some piece of paper out of the Home Office that satisfied the position, or digging around trying to find documentation for every year of their life. That too required compensation and was in a sense part of the Windrush scandal, but it was not nearly as extreme as people who, like Mr. Howard, who actually lost their job because they couldn't satisfy their employers. So there'd be all sorts of gradations.
There may
The
be.
policy, in fact, would require individual evaluative judgments.
Well, that may
wouldn't it?
be what the Secretary of State decided to do, or the Secretary of State might decide to do. Well, as with any structuring of a policy, there are blurred lines, there are hard
Yes.
cases, and it's going to be much, much easier just to create certain categories for
Then
it.
you get in, I suppose your answer will be, well, this is something you had to put up with, but I think that's very the sort of point, though he didn't go into the detail we just have, that Sir James was making when he was saying that these Article 14 difficulties, as soon as you start drawing bright lines, you're going to have Article 14 difficulties, because people will say, if you relaxed the good character requirement only for those who'd lost their jobs, people will be saying, well, what about me? I didn't lose my job, but I had a hell of a time keeping it, and I too have been affected by the Windrush scandal.
Which is no different to the way in which the other elements of the criteria have had to be ameliorated. So, for example, the 5-year rule. You know, they have to have room to dispense with the 5-year rule, and you've got to make decisions on the basis of those individual circumstances. It's not different. Maybe difficult to go through the exercise because you have to consider all sorts of different considerations, but that's what happens day in, day out in the construction of and structuring of a policy, a government policy. It's no different in any sense. And how sensitive the calibration is a matter of choice ultimately.
Yeah. Okay, I see exactly how you put it.
So those are our answers to all the criticisms that have been made. Can I then turn to the issue raised by my Lord Justice Baker, I think it was, about the terms of the policy itself, or was it my Lord Justice Underhill, about the terms of the policy itself being sufficient to cater for any exceptions?
My Lord.
So I don't think it's necessary to take you back to it, but I will do if it would help. But we saw that there was a reference to normally. There was then the identification of paragraph 15 of looking at Roman numeral 15 of the exception being exceptional, and then there was reference to a further paragraph which identified the sorts of factors that might.
It would help me with my.
So if we take ourselves back to that, then that is in.
That's the authorities one, isn't it?
It's not actually. It's in SB2.
Sorry, SE2.
SB2, Annex D, at page 199 is where it starts. But we want to take a look at, starting at 204, the key points in relation to the table of offending and offences. And then we got down to 15 on page 205. So where the section states an application will normally be refused if a person has been convicted, exceptions should only be made in exceptional circumstances, and then it points us down to section 10.
So before we get to that, I'm just thinking about minor offences. That would involve a change to table 2.1, would it?
Yes, for the particular cohort, exactly. However that cohort was defined, you would then have to make that change. Or you could have that table and then have a heading dealing with Windrush, or you do what has happened in relation to all the other measures, which is to have it built into the scheme. And so where anyone is dealing with a Windrush applicant, you look at the Windrush scheme. But wherever you deal with it, the point I am seeking to make on the basis of the terms as they currently stand, and I think we do need to look at section 10, is that you simply cannot cater for an allowance needing to be made for the Windrush generation, given the terms as they actually stand now. Because they are all directed to the exception being by reference to that person otherwise showing good character. So you take the calibration in that table as standing, but you look for features that point to that person nonetheless being of good character.
Yes, I mean, this is not a debating point against you, so I can be clear. This is, in a sense, a point against you on the, what I might call the vires point.
Well, it's simply, the fact that it does that doesn't mean that that's the proper construction of the statute.
No,
And we can certainly see that that's not how decision makers understand the statute because of the decisions taken in Mr. Howard's case. I mean, one of the things we don't know, because the point was never raised, the Padfield point, we don't know how often decisions are made which make exceptions because of circumstances like somebody nearing their death or other circumstances which are not identified there. But what we do
how
know,
would that help us as a matter of law?
well, it doesn't, which is
No.
precisely why I'm saying the words of this policy do not help us as a matter of law in terms of.
But what? Yes. What? Have I got this right? Perhaps I didn't write it down at the time. You must reformulate it if I've got it wrong. All this language of normally, exceptionally, generally, is directed to circumstances which could, in theory, go to good character.
Yeah, so despite the conviction, the person has nonetheless
Yes, quite.
lived a life contributing to charitable organisations.
Yes.
All focused on character, not such
Yes.
as to distinguish this cohort
Yes.
by reason of their characteristics of long connection to the United Kingdom and total integration. So it is incapable, as it stands, of meeting the particular
Do
objection.
the exceptions under Section 10 have to relate to good character?
Well, Section 10, they don't have to, in the sense that the Secretary of State could make the exceptions relate to anything. But at the
Yes.
moment, it is very difficult to see that they do anything but. And when we then see the decisions that were made, the first two decisions that were made, they're just a standard application of the wording and the
Yeah.
approach set out.
But
in.
generally, the categories of exceptions are not closed.
No,
Section
but you need to structure it. So if you're going to give effect to the principle driving the approach to the Windrush generation, you need to structure it to make sure that decision makers are properly taking into account, in whatever way the Secretary of State decides there should be account taken, of the scandal, long residence, and close connection or total integration into the into the United Kingdom. And it just isn't capable of doing that. And another point to draw your attention to on the same lines is Christian Armstrong's statement, which we looked at earlier, because he draws attention to the citizenship application form completed by Windrush applicants, and he makes the point at paragraphs 28 and 29, that's an SB1, page 30. So yes, that's page 30, paragraph 28, and if the court reads paragraphs 28 and 29,
Yeah.
and then 32. And that just makes the point. It's not considered to be relevant to the question of good character. Length of time spent in the UK, these factors are just not considered to be relevant to the question.
But they are relevant, aren't they, to the requirement to pass a test about English language and so on, and potentially to the requirement to pay fees, and those have both been waived.
Well, yes, precisely. That's exactly our point. They are relevant, and they should have been factored in.
So that the requirements that bear on integration, length of residence, the statutory requirements, have been waived, but the statutory requirement that doesn't have any connection with long residence and integration, i.e. good character, hasn't been waived or modified. So in a sense, your submissions about the guidance emphasise that actually good character has got nothing to do with integration and long residence.
That simply goes back to
Yeah, it goes
point
back to
as
the original
whether-
point,
It
yeah.
does go back to the same point, and waiving requirements which have obviously no application whatsoever to people who were born here and brought up and went to school here, i.e. language and knowledge of Britishness, is in one sense doing nothing at all.
Well, it is, because otherwise they'd have to jump through the pointless hoop of passing the test,
But
and
the
they'd have to pay
pointless
the
is
fee.
they necessarily meet that requirement, and it's obviously of no application to them. In relation to the good character requirement, the question of whether it's appropriate for them to acquire British citizenship, despite the fact that they have convictions, is one in our submission where the length of time they've been here, their connection to the British, to Britain, and in the context of the scandal, does bear upon whether or not it's appropriate, despite certain convictions. But coming back to these points, in our submission, the policy as it stands cannot cater for, has not catered for, look at Mr. Howard's own case, 4 decisions where really nothing had changed before they reached a decision that probably took account of his long residence. It cannot cater for that which we say as a matter of principle is required to be factored into this policy. And so it really is an issue of the legality of the policy, if we're right on everything else being equal. Unless, if your Lordship will bear with me. Unless I can assist any further, those are our submissions.
Yes, of course.
I'm sure this is my fault, Ms. Kaufman, and forgive me if that's the case, but I'm still not sure I understand why it is, assuming you're right about the principles and what the principles require, it was unlawful for Sajid Javid to resile from them, if that's what he did.
Because at no point has he articulated, let alone for any good reason, a different approach, a different principled approach as to the way in which the government is going to respond to all the factors identified as giving rise to
I see.
the scheme.
All right, thank you.
Thank you.
Yes, James.
My lords, my ladies, subject to the diligence of Mr. Blundell and Ms. Brown overnight, on the Section 2 issue, you asked about Annex D.
Oh, yes.
Annex D is Annex D to Chapter 18 of the Nationality instructions, which are instructions to caseworkers.
Thank you very much indeed.
My lords, my lady, the position we've reached is that this, as Ms. Kaufman repeatedly acknowledged, is not a legitimate expectation challenge, or therefore a challenge which is based on Amber Rudd's statement having been a promise or commitment of the kind that would be necessary to ground that doctrine. That had at one point in the changing landscape as to the target that we were confronting been the case, but no longer.
Ms. Kaufman seems to be disagreeing.
You said you were going to show us where...
I'm going to give you the references.
Yes, thank you.
I'm not going to go through them because it would be tedious in the extreme,
Yeah.
but the Statement of Facts and Grounds, Call Bundle, tab 17, page 174, beginning at paragraph 35, which will put quite as legitimate expectation, but based on promise or commitment. See in particular paragraph 37. I'm very happy to go through them rather than just give you references. If it would be easier, perhaps it would.
Paragraph 37, did you say?
Yeah, sorry, just let me get them so I can follow it through.
Yeah, so paragraph 35 introduces the point. Scheme unlawful, inconsistent with public statements.
Yeah, you
about
see the way it's
purpose of
put.
the scheme.
And then paragraph 37, in particular, after lots of references to various statements, requirements for applicants under the scheme to satisfy the good character requirement is materially inconsistent with the statements. Bottle, bottle, bum, and then look at the last sentence of 37, public statements and commitment. So you've got a claim, not quite sure what legal clothing is being put on it, based on inconsistency with statements and or a commitment.
Yes, that is consistent with the way in which the judge eventually found it, isn't it? I agree, you probably might, when looking at it, treat it on first reaction would be that's a legitimate expectation claim, but it's not necessarily.
It's not
But
necessarily.
isn't the important point that Ms. Kaufman has now disavowed it?
Yeah,
I know I asked.
Exactly.
But I didn't know she was going to disavow it, so I wanted to.
That's what I'm getting you. That's what
Yes,
I'm getting
okay.
you. That's
No,
the
but
starting.
James did say earlier on, this morning, that he was going to
did.
show us.
No, I know.
Yep.
I did.
Keep
Anyway,
going.
that's the start of it. And true, there's quite a question mark throughout these proceedings leading up to and during trial as to what legal clothing was actually being put on the broad assertion that this was all inconsistent with the commitments made in the statement. But that's the derivation, or that's the starting point of it. Then our detailed grounds in response, tab 13 of the same bundle, at page 140, in the red numbering in the middle. We respond to, you'll see the title above paragraph 29. And we make a bit of a complaint in the first sentence of paragraph 31 and in the first sentence of paragraph 33 that we're not actually sure what they're making of that in terms of legal clothing, but we address it in substance. Then, so that all those statements were under what used to be called ground one, and then I think ground one was then abandoned in the claimant's skeleton argument below. See tab 11, page 99, paragraph 12. You'll see the reference to maintaining two bases of challenge. The first one was Article 14, which is now gone before you, and the second one, you'll see how the legal clothing was at that point put. Unreasonably fettered her discretion for facing, and then it became failed to take into account relevant considerations, which led to rouse, and then it became substantive irrationality during the hearing. But this is the abandonment of ground one, effectively. And then we made the point in our skeleton before Mr. Justice Swift, tab 10 at page 92. Paragraph 56. And then you'll see what we say in the final sentence of paragraph 56.
Yeah, thank you.
So that's the way it went.
Yeah.
There was a claim based on, I hope that does what my lady was hoping it did, that there was a claim based on commitment or promise, that there was continuing uncertainty about its legal clothing, but it was ultimately abandoned as a point. So we are not dealing with legitimate expectation, and we are not dealing with anything which is said to be, just in case there's any significance to it, a commitment or promise, whatever its legal clothing is called. So there is nothing of the requisite, it is accepted, there is nothing of the requisite clarity or unequivocality, to take the language from the precondition, to a legitimate expectation, even in the statement. And that is, it appears, common ground. But secondly, it may be an aspect of the same thing. My learned friend accepted at the outset of her submissions that the Secretary of State was not bound by policy said to have been declared. And thirdly, there is, it appears, no dispute but that the later office holder could depart from a decision of his predecessor.
The
But that seems to be qualified by the submission that he could only do so if he articulated a good reason for doing that.
Well, that does seem to be the position now, but no claim has ever been made to that effect. And you will note that that is why the Rouse statement is cast as it is, because the Rouse statement was put in to deal with a suggestion as it was at that point that there were things that hadn't been taken into consideration, including the position of the Windrush generation. And in any event, just to sweep away this point, if I may, if the principles, I thought we were going to be talking about legal principles, but it appears that by the reference to the principles, my learned friend meant her principles, in other words, Amber Rudd's, in inverted commas, principles as set out in the statement. And if they are her principles, then that whole idea must carry with it the proposition that she could change them. I think that was the subject of a question my Lord Justice Baker asked. Do you accept that she could change them? But there could be no objection to her changing them. Or indeed, it follows a fortiori, a later Secretary of State. So she now says, the case we now confront is that the Secretary of State was bound by what are described as the Rudd principles. That is, so my learned friend said, a recognition of long residence and or integration.
And ill treatment through hostile environment, etc.
Yes, and ill treatment through that. And my answers to that, if I can give you 5 short answers in relation to that. The first of them is that a Secretary of State or the government is not bound by a statement unless it has the degree of clarity required for a legitimate expectation.
Or for a statement of policy.
Well, or for a statement of policy, but that may come with slightly different principles.
Sure.
And I was going to remind you at some point, but I'll do it now.
Yeah.
You'll be very well aware that the Supreme Court recently has been considering when a statement represents or can represent policy of a kind to attract the public law principle that says you're bound to follow it unless you've got good reason not to. They did so in the A case, as you remember, very recently, and again we can send you these authorities if you need them by email afterwards, but the A case they did so, in paragraph 3 there's a long reconsideration, or a relatively long reconsideration of the basis of principle on which policies might be said to be binding in the judgment of Lord Sales and Lord Burnett, giving a joint judgment with which the rest agreed, if you recall that case. And they visited it again in a slightly different context because it was to do with the idea of a policy in a particular statutory scheme in Heathrow, whereas you may or may not recall, but they there disagreed with the Court of Appeal in holding that various ex cathedra statements made in various different locations did not amount to policy for this purpose. And what was needed for the purpose of a policy being created under the Act was something of sufficient specificity and clarity into which proper government consideration had gone to give it a formulated feel, if that makes sense.
Yeah.
So you've got those ideas floating around. But my submission of principle, my first submission of principle, is that the government is not bound by a statement of that kind unless at least you've got the requisite clarity. What I do not accept is that if you are not in that territory, in other words, if you are not in the territory where you can say there was a commitment or promise or something of that clarity and unequivocality, you can in effect produce exactly the same legal effect through rationality and just call it rationality. And that is no doubt why, and nor can you do that by reference to the policy principles that my lady identified, and that is no doubt why, when there was that reconsideration of how policy statements work, and it was subject of a recent judgment of the Divisional Court in All the Citizens that Lord Justice Singh and Mr. Justice Johnson handed down the other day about policies, But that is no doubt why the Supreme Court was saying there is actually a very close link between the idea of a legitimate expectation and the idea of a policy of the requisite clarity which would lead to the principle that says you're bound to follow the rules unless there's good reason not to. But we do not accept that you can effectively escape from the prerequisites of clarity in either or both of those contexts simply by dressing it up, accepting that you can't reach the level of commitment, promise or something of that clarity, but nevertheless achieving the same legal effect by attaching a different tag called rationality onto it. Secondly, even assuming for the sake of argument that you could get round that fundamental problem of principle, you still have to confront the problem. You need a standard, you need a legal standard for ascertaining whether you are truly dealing with what my learned friend rather airily called principles. What is the standard? My respectful submission is that standard must have a requisite degree of clarity. And if you're there, the question of principle becomes, why should it, as a matter of principled public law, be different from the sort of clarity that you would require for a policy statement to engage the policy principle or for a promise or commitment which would be needed for the purpose of legitimate expectation? Drawing distinctions based on legal label is incoherent. And that's what led me to thinking, well, that's quite interesting because the Supreme Court have opined on this relatively recently in A and Heathrow. So they are perhaps worth a look on that front. We'll give you the relevant paragraphs. But thirdly, it is worth bearing in mind, if all of that cannot be overcome, what, in inverted commas, principles my learned friend relies upon. She does not in truth really want to rely, or shies away a bit from relying, on the bits of the statement that you would have thought she would rely on, because they're, as it were, more extreme in her favour. She does not rely on British status if you want it, those sorts of statements. And the reason she doesn't do so is because they would prove too much. And they illustrate the limits within which those statements in the Amber Rudd statement operate, including in particular the limits that are imposed in the primary by the non-waivable requirement for good character. Instead, she says, long residence plus a bit of injustice for the Windrush group, or injustice for some of the Windrush group. But that only, as you recognise, goes so far. So that's the context in which the statement is made, and the limitations of it, and the explanation for why she doesn't go the whole hog with the logic of the argument in relation to what was said by Amber Rudd in Parliament in the statement. What then, question anyway, is what were the statements or principles? I'm not going to go back through all of that. You'll have formed your own view about the statement, and you've obviously read it with care on a couple of occasions now already. But just to bear in mind, this was not an absolute promise that you would get British citizenship if you were long resident, integrated and or had suffered the injustice of Windrush, and it couldn't be. This was not a promise to repeal or invite Parliament to repeal primary legislation. There was no reference whatever to good character in the statement. There was a reference, and repeated reference, to things that were being done and that would be done. This was not a promise or commitment to act in all spheres relating to the possibility of British citizenship being granted to Windrush people. This was not a commitment to do everything within the limit of the Secretary of State's power. On the contrary, we entirely and respectfully agree with my lady's point about the structure of the statement. What was being done in this statement was to say, there's an almighty historic problem. We recognise the problem, we apologise for it, we've got to take some steps to deal with it. Here are the steps we're going to take, 1, 2, 3, 4. And those steps were identified. And so when you come to that paragraph on page 125, which starts with, I want to enable the Windrush generation, which my Lord described as the key sentence, you've got various bits in there. You've got deserve, you've got through the process, and when you get quickly, and you've got when you get to the end of that,
proactive resistance.
yes, and when you get to the end of the paragraph, in effect, that means that anyone from the Windrush generation, the question that's posed, it might be thought as a matter if you were construing this as a statute, would be, what does that mean? Well, that perfectly obviously refers to the 4 steps that preceded it. So that's the basic structure of the statement.
It is, if you were construing it as a statute, subject possibly to the words in effect, it is actually a mischaracterisation of the 4 steps because it leaves out.
We won't be able to do some things.
If you're of bad character, you still won't get it.
But deserve is there. So
Deserves.
I mean, of course, we mustn't overinterpret it.
No, and one comes at it as a parliamentary statement in a fraught environment. So, my Lord, quite so.
Yeah.
So that's that is the position. And if it does mean, and if the principle is, well, effectively the position of the Windrush generation with all the injustices that were attached to the position of some of them, then that is the premise for the policy choices that then follow. What then do we do about that? So that's the third point. The fourth point is that her way of looking at it proves too much. Her promise, or her commitment, or her principle.
Her being
Miss Kaufman, I'm so sorry.
not Miss Rudd.
No, not Miss Rudd. Miss Kaufman's asserted principle, imputed principle, in effect leads to a commitment to repeal which is not made. Fifthly, the judge reasoned it as rationality. The question that rationality poses is therefore the rationality question. An objective question: could a reasonable or rational Secretary of State who hadn't taken leave of his or her senses decide not to change it? That's the question. And her answer, that's my learned friend's answer, at the outset of her submissions when the question was put, whether she, that is the Secretary of State, could legitimately and lawfully say, I'm not going to change my policy, was to pause for a moment and then say, well, no, she couldn't, because of her principles. But that implicitly accepts that if her principles were not as Miss Kaufman asserts them to be, then she could do so. She could rationally draw that distinction, and we agree.
So has the judge, in a way, in paragraph 35, applied, mixed up the Wednesbury test with the test for departing from a published policy?
He does appear to, he gets quite close to doing that, with the references to compelling.
Well, he says, even if I have a significant margin of the Wednesbury reasonable standard, blah, 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 no sufficient reason to explain why, when it came to good character requirement, no significance was attached. So it's as if he's he seems to be suggesting that the Wednesbury reasonableness standard somehow implies that you've got to explain why you haven't done something.
Yes.
Which seems to echo the test for departing from a published policy.
Well, it does, but even that would overstate even that.
Yes,
because normally it's good reason with a rational judgment attached to it for departing from policy. So we overstated it even on that basis, and that still would come down to rationality, Because when you're assessing whether there's good, that it might be thought is the interesting principal distinction between legitimate expectation and departure from policy.
So there seems to be a
merge.
conflation of about three different standards.
And moreover, when you come to the bit that we first looked at, where compelling reason was referred to, which is the second line of the next page,
Yeah.
when he's dealing with vulnerability to legal challenge, he's doing something else again.
Yes.
And heightening the standard yet further. I said that might be the difference between departing from policy and legitimate expectation, because, as you're aware, when you get to departing from policy, it is the good reason for doing so. That's a straightforward, rational judgment for the executive. If you're doing legitimate expectation, because of the weight of the promise, no doubt, and someone relying on it normally to their detriment, it's a question for the court to work out whether it's fair to allow you to depart from or resolve from the promise that you've made. But either way, that matters not. But I respectfully agree there's a problem there. Just to come back to the principles as well, sorry, I should have made this point in relation to my third point when I was trying to analyse what the principles were. You do need a bit of precision, I respectfully submit. If the principles are, which appear to be in the end, my learned friends, as it were, best way of putting that point, if the principles are said to be, I, the Secretary of State, will do everything within the limit of my powers to make naturalisation happen. Let's assume that's the assertive principle. It's not quite how my learned friend put it, but assume that that was the argument. Then there would be difficulties, because that is, if that's the effect that is asserted, one, that is not what is said. Instead, very specific steps are identified. Two, if that's right, what does that then commit the Secretary of State to? She had to change the system, if you're dealing with the good character policy, but how? And what in the good character policy is the limit of the powers if she's committed to do everything within the limit of her powers? What attitude is she required to take to the degree of legal risk she's prepared to assume in relation to whatever changes she makes? So there are problems with, at the point of identifying what the principles are, principles that my learned friends ought to rely upon, all, aka the promise. And those difficulties, I respectfully submit, are illustrated by the question which my learned friend was asked to address, which is, well, how do you do it? What do you accept is permissible on her approach? And that's a thoroughly relevant question for all the reasons I indicated in the opening. And her answer was, well, you could do a whole variety of things. I can't tell you, I'm not the Secretary of State. Secretary of State would have lots of things that he or she could do.
E.g. the things that were proposed in the
submission to Amber Rudd.
Yeah.
But you could reduce the time shadow of the sentences. You could take out minor offences. You could do any and all of the above. But the difficulty with that answer is that it is illustrative of the broader problem which her case has to confront. First of all, she effectively accepted that, except for doing something which could properly be described, as my Lord the Vice President put it, as de minimis, it would be open and lawful for the Secretary of State, in relation to the good character policy, to do almost anything by way of reaction, however light. And it is extraordinarily difficult, I respectfully submit, to see how the slither of a difference between doing something extraordinarily light, which he accepts as lawful, and deciding to leave the good character requirement and policy as was, could possibly amount to irrationality. But secondly, it is illustrative, that answer, of our fundamental point, which is that these are issues of policy and politics, to which there is no right answer. There are only judgments about how the policy is set up under the good character requirement. and that is illustrated by her acceptance of the range of things that could be done, including, I would add, that you might need to have different adjustments within the cohort to reflect the different injustices that they may or may not have suffered. But all of that is, we submit, and this is the legal punchline, that all of that is significant because it illustrates that this part of the policy framework to do with good character is distinct from and fundamentally different to the sorts of steps that Amber Rudd referred to as her specified steps in Parliament, waive the fee and all of that, all very easy. This is much more complicated and much more complex and much more difficult for all of those reasons and all the reasons I went through in opening. And what that tells you is that to base a judgment of irrationality on what is asserted to be a legal distinction, or the absence of a legal distinction between the various species of action, things done and things not done, things done being waive fee, etc., things not done being change the policy, cannot possibly be irrational because there are obvious differences between the two characters and the two things that you're thinking about. Thirdly, this exchange also illustrated that there is, on my learned friend's case, a total disconnect between, on the one hand, the feature driving the need to change, long residence, Windrush, injustice, on the one hand, and on the other hand, an acceptance that it would be perfectly lawful only to make the most minor of changes to the good character policy, which he accepts is fine and dandy. If you made a tiny change to the policy, which you would accept was lawful, going beyond something simply de minimis, that plainly would not apply to many, if not most of, the Windrush generation. Finally, in relation to Padfield, we do respectfully submit that there is a problem with statutory purpose.
Do you acknowledge, Mr. James, that this wasn't put this way below?
I do. I do. I mean,
I think my recollection is right that it was raised by you before it was raised by me.
Yes,
This morning.
it was.
You certainly mentioned Padfield first.
I certainly mentioned Padfield.
I'm glad about that. You see, I resent the idea that I've fed you a point you hadn't thought of. Which
I
is
can't
very
say
unlikely.
which of you thought of it first. This morning over breakfast.
I've no idea what the answer to that prior question is, but I think this morning I did get my guns in first. But I'm not sure whether
In any event,
that may not be a good thing
but
or a
it
bad
wa-
thing.
You showed them.
Yeah.
Mr.
But
Blackburn,
my
in
point-
good
my-
sense, has not attempted to take any.
No, she hasn't, and that I respectfully submit is a proper and fair position as we would expect from her, and is pretty much consistent with the way in which this litigation has been done. I mean, you'll have seen from the judgment that
You say if she's kept changing her case, you should be allowed to do it once.
I don't quite say that. I say we've both been pretty forgiving of each other during the course of this litigation, and hopefully that spirit will continue.
Okay, by the way, just back to substance.
Yeah, the more fundamental point is that if this is a problem, it's a problem that's now been raised, it's a problem of principle, and it's a problem which the court will presumably wish to grapple with as such. But I do submit it is something of a problem if what you are saying is, as the judge did, that you need to take account in relation to the good character policy, the policy change that needed to be made, as part of rationality, was a change that related to matters which had, at least in some cases, or would have had, at least in some cases, no relation to good character at all.
Well, is that the problem with the line of questions I've been putting to both of you about the scope for
What you can do under the existing
factors under word
under the
generally, which you certainly didn't like when
I did circulate, and I still do, and I think the position that I got to when you were taking me to task on that in my opening submissions was to say, well, there may be certain circumstances in which some of those factors, probably coupled with other things, you've been here a long time and you've been engaged in various activities as a result for a long time, might bear on good character, but you needed the other things. In other words,
Yes.
do you see what I mean? If
It
you're
rather looks as possibly as though that's what happened in the end in this case, although it's not.
well, I'm not sure.
I mean,
That's a more difficult thing because if one reads between the lines,
obviously that doesn't.
there was murmuring, but I think there was murmuring because the real driver in that last letter looks as though it might well have been the state of illness of poor Mr. Howard, and that may be quite difficult to relate back to good character rather than being compassionate circumstances. So the problem only arises if you've got something which you can't, hand on heart, connect to good character.
Well, the way Section 10 is drafted, it may well be that this isn't permissible under the statute, but the way Section 10, that Section 10 is drafted, does, on one reading, seem to allow for citizenship to be granted. Should we look at it?
Yes. I was frowning only a
I
bit.
always forget where it is.
It's in supplemental bundle 2 and paragraph 10.
Already open, buried on there.
225.
Yeah. The main exception case where a person will be granted even where they ordinarily would fall to be refused.
Yeah. But that's ordinarily under the rules that are set out.
Yeah.
And the rules that are set out are the rules that sit under the general heading of good character requirement. That's the title of the document.
Okay. Well, you did say.
But then the difficulty is if you get to B, which is probably the broadest.
It's very much confined to good character. So, you were very hesitant about seeking to put forward a justification for what happened in this case.
Yeah. But on the right side, I suppose, of the compassionate scale, if not the legal one. But there is a difficulty. On one view, in relation to Padfield, you don't actually necessarily have to grapple with or decide finally whether they would or they wouldn't be. The learned friend sought to present this as being an issue of varies which you have to determine as an issue of varies. The fact of the matter is that what we're dealing with is a rationality judgment. And what is being said is you can't distinguish between good character policy on the one hand and waiving the fee on the other. It doesn't make any sense in a context in which the one and the other are likely to be driven by the underlying features of Windrush. And if you have got, I'm so sorry to interrupt.
You carry on.
If you have got a species of legal risk that is created by a particular type of change of policy, then that is likely to have a legal side to it. It's also likely to have a coherence policy side to it, particularly in a sphere like this. And what it does do at the level of risk rather than resolution is to create a distinction between the one and t'other.
For that reason, we could, if we were going to, decide in your favour on a basis that alluded to this difficulty.
Yeah, without necessarily resolving it.
Is that a hint that you would rather we did that?
Well, not necessarily. I don't at all mind you resolving it. My point is that my case is a good one at a point below resolution.
I see that.
That's all. I'm certainly not discouraging it or.
Well, we'll have to decide what we want to do.
Decide what we're going to do in relation to that. So those are the points of substance. I'm not going to go back over the points I made in opening. I focused on these aspects in response. But I do remind you of the fact, as I hope I made clear at the beginning, that the judge's reasoning wasn't, as it were, binary in this way. The judge took a variety of different strands and he said, well, none of those work. And I've given you my submissions in relation to all of that. And our fundamental point is that having at least paid lip service to the idea that this was a rationality challenge and rationality was a high standard, he does appear, when he goes through the analysis, to have, to put it at its lowest, drifted from the point of principled purity in relation to that. So those are my submissions.
Thank you. I've just got two very minor. One which has troubled me in these cases from time to time. The so-called hostile environment was, I believe, that was actually the government description of it when it was first introduced. It has more recently been referred to as the compliant environment.
Yeah.
The problem is whichever you use,
It's got hostility or
it
compliance.
appears partisan one way or the other.
Yes.
What was it called at the time that it applied to Mr. Howard? I suspect it was still called the hostile environment.
Again,
Well, I don't think it really matters.
No, but if you want to make a statement of some kind.
I've always felt awkward. Sometimes you phrase that the so-called hostile environment. But, leave it up to us. We will decide what to call it.
If there is an answer to the factual question, what was
Yes.
it called at the time, then we'll put it in with our section 2 email, if we may.
I suspect there was a moment at which, for
There was a
political or
conscious
legal
decision to
reasons,
change
it was decided to rebrand the policy. I wouldn't mind knowing when that was.
Yeah, well, we'll find out.
Second point, yes, you have referred to a couple of authorities which haven't featured so far, basically A and Heathrow,
Yeah.
and indeed very briefly to the Divisional Court decision last week. And you said you would give us the references to those. I think if you take that course, Ms. Kaufman, in principle, must have the right to say something about them. The way I see it at the moment is that they are very much marginal.
Yeah.
Having said that, I couldn't promise Ms. Kaufman that I wouldn't probably just look at them, see if they said anything that was useful. So it's a slightly unsatisfactory halfway house. Ms. Kaufman, is anything you want to say now about those authorities? Or you may say you have to reread them before you can say anything useful.
I think I probably have to reread them through the
I
prism
wonder
of
whether
this
we
case
can leave
before
it
I say
this way. We will, just to save us faffing about, accept the offer to have them sent to us, and they can be sent to you at the same time. If we regard them as of fundamental importance, we will invite submissions. If you don't, I don't mean this rude, if you don't trust that and actually look at them and think there are things you possibly want to say, I think you must have the right to do so. But I'm not inviting you to, because the way it looks at the moment is they're slightly marginal. Is that a fair compromise?
Well, I'm entirely
Content
content
comes up
if Ms. Kaufman.
Fine, sounds fine.
And we'll try and identify the paragraphs that we think are a bit relevant.
Well, I think that would make it easier for everyone, but at the moment I doubt it occasions me to turn on them anyway. Well, it just remains to say thank you to both of you for extremely cogent and succinct submissions. We will, of course, be reserving our decision. Draft judgments will be circulated in the usual way to enable the parties to make submissions on consequential, well, to reach agreement about consequential matters, and if they can't, to put in short written submissions so that we can resolve them before hand down. Also, of course, to draw our attention to typographical or other minor factual errors. And I think we nowadays feed in to this little exposition the importance of treating the draft documents as confidential. If you have any doubt about exactly what the parameters are, please reread the General Counsel for Wales case. Thank you.